Welcome, everyone, to this next episode of the Berkeley Center for Law and Technology's Expert Series webcast. We have another great lineup here, coming from two different offices of Morgan Lewis to give us a multi-jurisdictional view of what's going on in this particular world. So we've got the topic is hot topics, and what is it? We limited it to biometrics and genetics, which is not a very small limitation. It's an enormous field. And if you're going to talk about biometrics, well, you've got to go to Chicago because that's where the action is in the country. But it turns out that there's action outside of Illinois and in this area. So Warren Rissier is going to bring us the California view, and Beth Herrington the Illinois Chicago view, and then of course both of them with Morgan Lewis and their national presence have an incredible national view of what's going on in these two areas. So with that, I'm going to get out of the way and turn it over to the two of you. Beth, Warren, thank you for joining us here at Berkeley.
Thank you for having us.
Yeah, thanks, Wayne. Hello, everyone. Thank you for joining us to discuss hot topics in biometrics and genetics. As Wayne mentioned, my name is Warren Rissier, and I'm a partner here in our Los Angeles office. And you'll notice in our presentation today that we focus on two Illinois statutes, and you may be wondering why, if it's hot topics in biometrics and genetics, why Illinois? And that's because Illinois has been at the forefront of the privacy protection law, particularly in these areas of biometrics and genetics data, and has two key statutes: the Illinois Biometrics Information Privacy Act, also referred to as BIPA, and the Illinois Genetic Information Privacy Act, referred to as GIPA. And the Illinois Biometrics Act in particular BIPA, is tremendously expansive. It has been the subject of many lawsuits, not only in Illinois, but around the country. And when it comes to talking about litigation regarding biometrics, as Wayne mentioned, this is where the action is. Each of those statutes establish strict regulations about how businesses and other entities collect, store, and use individuals' sensitive biometric and genetic information. BIPA, as I mentioned, is one of the most stringent privacy laws in the US. It imposes consent, retention, and disclosure requirements for businesses that collect biometric data such as fingerprints, iris scans, scans of face geometry, provided that they create a unique biometric identifier. And similarly, GIPA, which regulates genetic information, restricts the collection, storage, and disclosure of DNA-related data, particularly by employers and insurers. Together, these laws make Illinois a leader in privacy protection, and that's why we're so fortunate to have my colleague, Beth Herrington. As Wayne mentioned, she's located in Chicago, and we've been involved with some of the largest, most significant cases that have been filed under these statutes. Beth, in particular, is one of the leading attorneys in the country when it comes to these statutes. To provide a couple of data points about why you should be pleased to be hearing from Beth, Beth is the only defense lawyer to have taken a BIPA case to trial. And of all the summary judgment victories across the defense bar, Beth has represented the defendant in a majority of them. So today we're fortunate to have the opportunity to discuss with Beth these statutes and some of the latest developments. And so Beth, could you start by helping us, for those who are maybe not as familiar with BIPA, the biometric statute, as others, with a little information about what it's about and sort of its history and purpose?
Sure, I'd be happy to. As Wayne mentioned and Warren mentioned, I'm a litigation partner based in Chicago, and Illinois has been hot in biometrics, and in particular, thanks to BIPA. And as Warren mentioned, it really governs the use of biometric identifiers. And what that includes in its definition is retina or iris scans, fingerprints, voice prints, scans of hand or face geometry, and biometric information that's derived from one of those biometric identifiers that could be used to identify an individual. Now, BIPA does not include any types of definitions as what constitutes a voice print or scan of hand and face geometry, and that's been the subject of a lot of ongoing litigation. But Section 5 of BIPA gives us a little bit of insight as far as what the Illinois legislature was thinking when it put together BIPA and it enacted it in 2008. The legislative findings actually demonstrate that Illinois had recognized the growing prevalence of biometrics in business and really wanted to encourage citizens to use safely biometric technology. And the stated purpose of BIPA is to serve the public welfare, security, and safety by regulating the collection, use, safeguarding, handling, storage, retention, and destruction of biometric identifiers and information. Now, to that end, BIPA does impose various restrictions and requirements on private entities, which are businesses, that possess, collect, capture, purchase, receive through trade, or otherwise obtain biometric identifiers or biometric information. So that's really why it went into effect on October 3rd, 2008. But since that time, the statute was dormant for a long time. In fact, from 2008 to roughly 2016 to 2017, there were no lawsuits pertaining to BIPA. But then in 2016, we saw a real proliferation in filings by class action lawyers. BIPA lawsuits grew and grew over the years, and there are thousands in Illinois and throughout the country. So most of the lawsuits are filed in either state court or federal court in Illinois, but we're also seeing them around the country where certain businesses that do business in Illinois are being sued where they're incorporated or where they have headquarters. For example, there are some suits in Washington, there's ongoing suits in California, as well as Delaware pertaining to BIPA. Now, what happened after the first lawsuits were filed is the Illinois Supreme Court came down with a really important decision called Rosenbach versus Six Flags Entertainment. And in that case, the Illinois Supreme Court said that to have a cause of action or to be aggrieved under BIPA, that someone didn't actually have to have any injury at all beyond a technical violation of the statute. When these lawsuits were first filed prior to the Rosenbach versus Six Flags decision, defendants lawyers like myself began to argue, well, wait a minute, no one's been harmed. There's a technical violations, therefore the case, the plaintiffs have no standing. And then the issue went all the way up to the Illinois Supreme Court, and the plaintiffs bar cheered because indeed the Illinois Supreme Court said no actual injury was necessary at all, and that claims could proceed even if it was only alleged that a technical violation had been committed and no one had suffered any actual harm. So as I mentioned, BIPA imposes really strict requirements on companies, private entities that collect, store, and use biometric identifiers and biometric information. So why don't we broadly, Warren, walk through what BIPA requires. We can take it section by section. There are 5 subsections. Do you want to take the informed consent section?
Sure. So with respect to informed consent, there are various pieces to this. Most companies accomplish informed consent through disclosure and policies as are typical for many terms, like a hyperlink to a policy or a hyperlink to terms that include disclosures in the policy. And the components that must be included is disclosure that biometric data is being collected, the specific purpose of the collection, the length of time the data will be retained, and the entity must also obtain written consent. So that means clicking I agree or the like, similar to how you would have agreement to terms of service. And What's important is that the statute doesn't prescribe any particular language that must be used. So a business has the flexibility to craft disclosures that are appropriate for its technology and for its consumers. The downside of that is that there's a lot of ambiguity, and sometimes in defending these cases, we feel like it doesn't matter what the company will have said, the plaintiff's lawyers will just say it should have been something different. Now, maybe that's just a jaded defense lawyer view, but that is the ambiguity in that statute about what is necessarily required for the informed consent to be effective has led to a lot of litigation. We're getting some clarity about that as the case law progresses, but still there's a lot of unanswered questions there. And then next is there needs to be a data retention and destruction policy. Do you want to take that one, Beth?
Sure, absolutely. BIBA requires that private entities must develop a publicly available written policy outlining how long biometric data will be retained. And it also provides that biometric data must be permanently destroyed pursuant to that policy when it is either no longer needed or within 3 years of the private entity's last interaction with the individual, whichever comes first. As Warren mentioned, there's some ambiguity on what is exactly required is under this provision as well. There have been a lot of questions as far as what's publicly available. If you think of a biometric or a finger scan time clock, some have argued that publicly available means that the policy must be present where the employee is using the time clock. Others disagree with that. Many companies place this policy in their privacy policy, which is indeed publicly available. But like other parts of BIPA, there is no clear guidance on what exactly it means to have a publicly available written policy. But, we do think that there's a number of ways that companies can accomplish that. And like I mentioned, putting it on the website in some form or fashion, whether it's by a hyperlink, whether it's another direct statement, seems to really accomplish the requirement that a data retention and destruction policy be publicly posted. Another provision. Oh, go ahead, Warren. Sorry.
That's okay. I thought I'd jump in here. We're trading off on these. So another requirement is that there's no profiting from biometric data. And so BIPA prohibits companies from selling, leasing, trading, or profiting from an individual's biometric data. And the case law makes clear that this doesn't mean just that the company is using the data internally for some purpose that allows it to effectuate some business function that may be part of its business and therefore revenue generating. This means selling it to a third party. Or leasing it or trading it to a third party, not the business's own use.
Oh, that's an excellent point on the profiting, that the companies cannot profit from biometric data. If you look at the legislative history in BIPA, one of the things that some of the representatives were concerned about when debating whether or not to enact BIPA was that there had been a bankruptcy by a company called Paycor, and Paycor had a whole big database of fingerprints of individuals. And one of the things that they were planning to do was sell the database of fingerprints. And the Illinois legislature thought, you know what, we cannot have companies collecting biometric information or biometric identifiers that actually identify people and then selling them for profit. So in other words, trading in fingerprints. So that is something that is prohibited. But I have yet to, as a defense lawyer, I've yet to see a company that has engaged in that practice. But it is prohibited. So I'll talk next about the limited disclosure. Section 15D NB really talks about, the data cannot be shared or disclosed unless the individual consents and it's required by law or valid subpoena, or it's necessary to complete a financial transaction that is specifically requested by the individual. So you see that in Section B, there's a requirement that somebody has to consent before the data is collected. Section 15D then says it cannot be redisclosed or disclosed outside of who originally collected it without consent. And there's very limited circumstances where they can without consent, but for the most part, private entities like companies should not be sharing or disclosing any biometric data without the individual's consent.
And then the last of the 5 requirements is data security requirements, and companies under the statute must use reasonable security measures to protect biometric data, applying standards at least as strong as used for other sensitive data. And so the idea is that if, for example, a company is storing social security numbers with certain strong protections, then under the statute, the company should also be storing biometric data with similar strong protections. And the rationale is that if one of the goals of the statute is to prevent identity theft, well, you should be protecting biometric data that can be used to identify an individual with the same sort of protections that you would use for social security numbers or other sensitive information. Now, Beth, we've talked all about the BIPA statute. It's not the only biometric statute out there, though, right?
That's right. That's right. There are other states, mainly Washington and Texas, that have specific biometric statutes that protects biometric data. But BIPA stands alone, at least right now, because it is unlike those other states, because it has a private right of action, meaning that plaintiffs can sue individually or as part of a class. It can sue the private entities. Under Washington and Texas law, only the AG can enforce violations of the statute. So what you're seeing is that the plaintiff's class action bar has really embraced BIPA because it has that private right of action. And also, as we're going to discuss, it also has some financial penalties or damages that have been debated as far as how they should be applied. And we're going to talk about a recent amendment that occurred. But right now, Illinois is by far the strictest state statute that's out there. And, that's why you see still thousands of lawsuits out there that involve BIPA.
Okay, so tell us more about why it is that the BIPA cases have attracted the attention of so many members of the plaintiff's bar over the last 8 years or so.
Well, sure. As I mentioned earlier, there was that Rosenbach case, Rosenbach versus Six Flags, where the Supreme Court ruled that actual harm, such as like an identity theft or financial loss, was not required to file a lawsuit under BIPA. So the plaintiffs only needed to show that a company collected or stored biometric data without proper consent, even if there was no misuse at all. So a technical violation alone got you into court. Another reason, as I mentioned earlier, BIPA permits relatively high statutory damages, including $1,000 per negligent violation, or $5,000 per reckless or intentional violations. And these can stack up quickly in the class action context. For example, if a company had used a finger scanner and collected fingerprints to identify individuals without their consent, damages could potentially reach into the millions or even billions if that company has thousands and thousands of employees' fingerprints tied to their identity. So that also, the high statutory damages combined with the non-requirement for any actual harm have made a very popular lawsuit.
And without mentioning any company names, we've seen in the past few years some really large settlements also that have received the attention of the plaintiff's bar. For example, in 2020, there was a $650 million BIPA settlement. In 2022, there was a $100 million BIPA settlement. And those kind of numbers really have got the attention of the plaintiff's bar and led to proliferation of lawsuits, small and large, right?
That's exactly right. They run the gamut from allegedly billions of dollars to tens of thousands of dollars, but the lawsuits have remained active, and there's a lot of issues still working their way through the courts that need to be decided. I'd also mention that the few times that we've seen the Texas AG take action were on the heels of those settlements that you mentioned, Warren. So there was an AG investigation under Texas law, the biometric statute there, by the AG involving Facebook, and then also by Google, in an investigation of Google, so you really kind of see the Texas AG had understood what the settlements were in Illinois and had taken action in Texas. I also wanted to mention that at Morgan Lewis, we are tracking other states. There's a lot of states out there every year that are considering passing their own biometric statutes. Some look favorably upon what's happening in Illinois. Others are not looking at it favorably and trying to get something that's a little bit, it has some of the requirements, in other words, protections for biometric data, but perhaps not the high statutory damages. So we're tracking that on a regular basis to see what's coming next. But right now, Illinois still is the biggest show in the country.
Okay, and it'll come as no surprise to the audience that we have an outline we're working off, but I'm going to skip something in the outline here.
All right.
And go to the subject of notable victories for BIPA defendants. As a defense lawyer, this is a favorite topic of mine, so we can skip over some of the jurisdictional stuff we were going to talk about. And particularly since we just talked about these giant settlements and we've been talking about all these components of the statute, there's a lot to do there. Can you share with us some of the notable victories for BIPA defendants that are making an impact? And I'll note that we're seeing a nice trend here where the early decisions, we're letting lots of things get by on the pleadings. We've seen a trend towards more recently some more defense favorable decisions, putting some reasonable guide rails around what the statute was really intended to do and things like that.
Yeah, and I do love talking about these recent developments because they are trending a little bit more in the defense way instead of just solely in the plaintiffs. So let me talk about just sort of three main topics. First is what I'll call the on-device only case. And in late 2022, the Illinois First District Appellate Court issued an important decision on what it actually means to possess, collect, or capture data under BIPA. The name of that case is Barnett versus Apple. In Barnett, the plaintiffs alleged that they used the Touch ID and Face ID features on various Apple products, and that those features work by means of a mathematical representation, and that the representation was stored on the user's device. In other words, on their iPad or on their cell phone. But once the user had stored his mathematical representation of his finger or his face, the device would compare the finger or face scan with the mathematical representation that was stored on his or her own device. Users could not access their own biometrics stored on their device without violating Apple's software license agreement. So the court interpreted possession under BIPA to have what it said was its ordinary and popular meaning, and that is to possess, to have control over something. And then the court addressed all the ways in which Apple designed the features, almost with the express purpose of handing control to the user, so not to Apple. The court, because Apple did not have access to the alleged biometrics in that case, the court could not find that Apple possessed plaintiff's biometric information. Whatever information was being derived from their face or their finger was stored solely on the device. So the court said that Apple could not have collected or captured data that remained on the plaintiff's device, and therefore affirmed the trial court's decision, reaching the same conclusion. So that's a very important a case because many companies have technology companies have software that runs solely on a user's device, and they write the programs so that all of the information remains on the user's device and it doesn't ever reach the company. Barnett says that in those circumstances, there cannot be a BIPA violation. And you don't even need to get into, whether or not it's a biometric identifier that was being collected, because whatever the information was or data was, it was not actually collected by the company. So, courts have distinguished Barnett in some limited cases where plaintiffs allege the defendant actually does have control over some of the plaintiff's data, but no court that we are aware of has disagreed with Barnett's reasoning. So it stands as a very strong statement that if the user's information doesn't actually reach the company, it's not collected by the company, there cannot be a BIPA violation. So there's actually been a recent case in federal court that I just wanted to mention as well. And it was a motion to dismiss ruling, but GT versus Samsung Electric found that Barnett was very persuasive, and it dismissed claims where a plaintiff failed to allege the defendant exercised control over biometrics that were allegedly on end users' devices. So important cases, because if there's no allegation that somehow whatever the information is that's allegedly collected was sent to the company, that those claims fail. So that's an important case.
Yeah, and that's brand new, just last month, right? I think
Yeah.
the day before Christmas, Samsung got a Christmas present. But it is good to know that if the alleged biometrics only on the device and doesn't go to the cloud, that's a really strong defense given the recent case law developments over in the past year.
That's right. That's exactly right.
I know that you have had a significant victory regarding extraterritoriality, meaning can you apply the BIPA Illinois statute to residents of other states? Can you tell us about that win?
Sure, absolutely. And actually, I have to point out there were several wins on extraterritoriality. We have successfully argued this issue in 3 different cases, receiving summary judgment in favor of the defendant in all 3 cases. Extraterritoriality in Illinois, there's a series of cases that talk about whether Illinois statutes can be applied outside of Illinois. And it's very clear that BIPA cannot be. And what that means is if there's activity that is occurring solely outside of Illinois, then BIPA cannot apply. So if BIPA had been intended to apply outside of Illinois, it would have specifically needed to state that, and it does not. So we first litigated this issue in 2 class actions that were brought by the same plaintiffs in the U.S. District Court of the Western District of Washington. These cases were Vance versus Microsoft Corporation and Vance versus Amazon.com Inc. And in both cases, we argued that the actions of the defendants there occurred solely outside of Illinois. The court rejected plaintiffs' argument that the relevant conduct had somehow occurred primarily and substantially, which is the test, in Illinois, merely because plaintiffs were Illinois residents who allegedly were injured in Illinois. The court instead looked at what did the defendant do? In both cases, they were alleged to have used a data set and reviewed a data set that allegedly contained biometric information. But they obtained this database that had been created by IBM for research purposes, and they had obtained it in Washington. So the court said that this allegedly unlawful conduct, receiving this database from IBM for research purposes, the acquisition of any of plaintiff's data in that database occurred outside of Illinois. It did not occur primarily and substantially in Illinois. So the ruling there, first of its nature, really on a summary judgment and summary judgment posture, was that BIPA cannot apply extraterritoriality. So it only can apply to actions that occur in Illinois. And there have been other federal courts that have applied the same reasoning. So I think this area of the law, in fact, just in late October, Amazon had another victory on the same ground in a case that was in the District Court of Delaware, McGovern versus Amazon Web Services. There again, the court looked at where was Amazon Web Services activity that was alleged to have violated BIPA. And the court said very clearly, in that case, AWS servers had allegedly routed voice prints. But even if they had done so, which of course Amazon very much denied, if they had, any type of voice print data would have been stored outside of Illinois and used by a consumer outside of Illinois. So, important for potential plaintiffs and certainly defendants to really consider, where's the activity occurring that you're claiming violates BIPA. If it's outside of Illinois, you may have a very strong defense that will be raised because it doesn't apply extraterritorially. So that's an important line of cases.
Yeah, and congratulations on those big wins.
Thank you.
Now, one other area that we're seeing is fruitful for defendants is to challenge whether in fact the technology is collecting a biometric identifier. And I could talk about a case that happened here in the Ninth Circuit, where I'm located in California, and that's the Zelmer case. And one of the holdings of the Zelmer case was that the biometric identifier has to actually be capable of identifying someone. Now, that may sound pretty basic, but the statute talks about collecting scans of hand or face geometry, fingerprints, retina scans, voice print, and so on, but doesn't give any definitions of those terms specifically, but it does provide other provisions of the statute and legislative history really talk about those things being unique biometric identifiers. And so there's law, including Zelmer and its progeny, that has developed over the last year that says it can't just be, for example, a scan of face geometry. It has to be a scan of face geometry capable of identifying a person for it to be a biometric or a biometric identifier. And that makes a lot of sense because the whole purpose of the statute was to protect information that could expose consumers to identity theft if the information was revealed. And so things like in Zelmer, it was numeric face signatures derived from a photograph that could not be used to identify an individual. So the Ninth Circuit held that based on BIPA's plain language, these were not biometrics. And so that's a very helpful decision. The Samsung case that Beth mentioned from also had another decision in July of last year, a bit earlier than the one that Beth mentioned, that followed the line of cases that said biometric information must be capable of recognizing an individual's identity, not simply an individual's feature. So again, on that same line of cases, and that's really important because the plaintiff's bar has been pushing sort of the limits of what the legislature might really have intended to get, we think, far away from what the core of the statute was really trying to do. And so those decisions over the past year, Zelmer and its progeny, are really important.
Yeah, and I'll just mention that there is, as Warren mentioned, there's two GT versus Samsung decisions, 2 motions to dismiss, both very favorable for defendants. They were the first complaint was dismissed. They got another shot at it. The second amended complaint then was, or I'm sorry, the amended complaint was then dismissed with prejudice. So 2 good decisions in the GT versus Samsung Electric case.
And Beth, I know you're intimately familiar also with the way that the damages landscape under BIPA has changed. And can you tell us a little bit about that? Because at one time it was uncertain about, was it 1,000 to 5,000 per person or per violation, or was it every time someone put their fingerprint on the scanner, it was a new claim? So if I checked into work 1,000 times, I would have 1,000 times $1,000 or 1,000 times $5,000 potentially, right? And that makes a huge difference.
Well, as absurd as that sounds and seems, that is what some plaintiffs' counsel have been arguing over the years. As I mentioned earlier, the BIPA statute permits damages in the amount of $1,000 or actual damages, whichever is greater, for each negligent violation. And $5,000 or actual damages, whichever is greater, for each intentional or reckless violation. And because each negligent violation or each intentional or reckless violation, that wasn't defined. As you mentioned, plaintiffs were saying, well, every single time an employee goes in, puts their finger down on a finger scanner for work, that each and every time, if it scans somebody's finger, that is a separate violation. So we would see some plaintiffs' lawyers taking this position, and it was called the per scan theory. No matter what the technology involved, everybody called it per scan. And what you'd see is some plaintiffs' lawyers really ratcheting up the damages, saying, well, I had an employee that came in 2,000 times. He came in and out every day. Here's his damage. What do you want to do with this case? How much do you want to pay? So that was a battle that was fought for a long time. In fact, the Illinois Supreme Court took that issue up. There was an important case called Cothran versus White Castle. And there, the court addressed this issue in 2023 and held that claims under Section 15B, which is the consent requirement, and Section 15D, the prohibition on disclosure, accrued under the Act with every scan or transmission of biometric identifiers or biometric information without prior informed consent. So the Illinois Supreme Court agreed with the interpretation that there could be a per scan theory. In other words, every time somebody's biometric identifier was allegedly collected, that could be a separate violation. So, however, Cothran wasn't just in favor of the plaintiffs. There was some good news in Cothran. Cothran's dissent talked about the fact that, well, yes, these damages, per scan theory, that can get quite high, but damages under BIPA, the Cothran court said, are discretionary. In other words, they're not required. Plaintiffs had previously been treating damages as if a technical violation occurred and it was mandatory to impose at least $1,000 or $5,000 per violation. But after Cothran, parties have been successful in arguing that damages are discretionary under BIPA. In fact, there was a damages award that we had vacated when a court agreed that damages under BIPA was a discretionary decision and a question for the jury to decide instead of the court. So after the Cothran decision, the Illinois General Assembly, having debated amendments to BIPA for years, actually passed one that was signed into law in August 2024 after Governor Pritzker signed it. The bill abrogated Cothran by stating expressly that a company or private entity, they collect the same biometric identifier information from the same person using the same method of collection, that entity only collects or only commits a single violation of Section 15B. So the plaintiff now, under the statute, the way it's written, is entitled to at most one recovery under BIPA. So using your example, the employee that goes in and out of work every day and scans their finger, and if a fingerprint is collected and a biometric identifier is collected, they are still only entitled to one recovery. In other words, $1,000 or $5,000, not every time they go in and out. It also clarified that under Section 15D, an entity commits only a single violation if there's the same method of disclosure. So 15B and D, it's limited to only one violation or one damage amount per person as opposed to per scan. So that was a very favorable amendment.
Now, even after that amendment, the damages that a company can be exposed to, especially a technology company that has a popular technology that's used by, say, millions of people, the damages exposure is still huge for them. If they're subject to the BIPA statute and potential lawsuits, meritorious or not, it's a risk. How are companies adjusting their business offerings when their technology is potentially subject to the BIPA statute?
Well, that's a great question. You know, even after the amendment in August 2024, there continued to be lawsuits that were filed under BIPA. So BIPA still remains a real threat, particularly, as you mentioned, for technology companies that may have millions or at least, you know, thousands of customers in Illinois. We are seeing that technology companies in particular are attempting to avoid offering technology in Illinois if possible. Because the risk is too great. As you mentioned earlier today, there's not precise language, say this in your consent. So I think that some companies say, okay, I'm going to try to comply with BIPA, but the risk may still be there that a plaintiff's lawyer could say the disclosure is not good enough or the consent's not good enough. So we are seeing some companies that technology companies that say, we're not going to offer it in Illinois. Similarly, businesses in Illinois, I've seen just workplaces have really, really moved away from using any type of finger scan technology in the workplace. So although that technology is used to prevent fraud in other states around the country, Illinois no longer, a lot of companies have gone back to the old days where you actually had a punch card and you'd punch yourself in and punch yourself out at the end of the day, as opposed to finger scans, because the risk of the lawsuit is too great, and the damage is still, the exposure for a smaller company can still be overwhelming, even in light of the amendment. So we're seeing some companies move away from any type of use of biometrics in Illinois, but we certainly work often with companies to carefully consider compliance with BIPA if they are going to use technology that even could remotely resemble the use of biometrics.
Well, that's unfortunate. It sounds like eventually Illinois will be like the Flintstones, and the rest of the rest of the country will be like the Jetsons. That's how we're trending right now.
Well, it's ironic, given that, as I stated earlier, the stated purpose of enacting BIPA was to give people confidence that biometrics could be used for transactions, and they shouldn't be concerned about it because it's going to be protected. Now, Illinois citizens, in many respects, will not be offered biometric technology in light of these cases.
So let's turn to talk about GIPA, the genetics statute. Can you tell us a little bit about what that statute requires and kind of its history and purpose?
Sure. GIPA was passed 10 years before BIPA. It was passed in 1998, and like BIPA, it sat dormant for many, many years. And it was enacted to promote public health by facilitating voluntary and confidential, non-discriminatory use of genetic testing information. So it prohibits the unauthorized use or disclosure of genetic information, prohibits employers and insurers from discriminating against individuals based on their genetic information. GIPA, as we call it, was drafted, with federal health and genetic privacy laws in mind. And that's what it was designed for. But actually, as relative to BIPA, there are actually very few cases addressing GIPA. It appears that in many ways, the GIPA was the sort of model for the language in BIPA, as BIPA actually borrows some of GIPA's language verbatim. For example, the damages provisions are very similar. So we haven't seen as many cases brought under GIPA, but there's still many that have been filed.
Okay, so it sounds like if you're a defendant and you receive a GIPA case, that looking to the case law interpreting the BIPA statute could be potentially helpful in litigating those cases.
Absolutely. For example, courts have interpreted GIPA like BIPA to mean that a person is aggrieved by a violation and has standing to sue, even if they have no harm beyond a statutory violation. So you see BIPA being used, the case law being used to interpret certain provisions of GIPA as well.
Okay. Could you tell us about some of the cases that we're seeing under GIPA and if you're noticing any trends with respect to those cases?
Well, courts, the most common suit that we're seeing is a potential employee who is asked a series of questions about their past history, health history, or potentially their genetic history as part of an interview process. That's what would often be seen. The people that may do a certain line of work where it might be important, how their past health history, and then that's what we're most seeing, the employer requiring a prospective employee to disclose their family history as a condition of employment. But courts in the Northern District of Illinois so far are split over whether any genetic family medical history actually constitutes genetic information, or whether GIPA only applies to family members like diseases and disorders that suggest another family member's genetic predisposition. So, for example, like cardiac health or cancer, rather than a broken bone or a viral infection. So it's still being interpreted, and as I mentioned, there was a flurry of activity where a lot of cases were filed, and we've seen a real drop off in the number of GIPA cases that are being filed on a regular basis.
Okay. So to wrap it up, is there anything that you see is coming around the corner that we should be keeping our eye out for, either with respect to BIPA or GIPA?
I think that we're going to continue to see a lot of the key issues really come into to really get a lot clearer. There are some plaintiffs' lawyers who are arguing, for example, that the recent amendment should only apply prospectively, and that it wasn't just a clarification of the existing law. So some plaintiffs will say if violations occurred prior to the amendment in 2024, that they should still be able to seek per scan damages. Now, there are cases in the Northern District of Illinois who say that's absolutely wrong, that the amendment clarified existing law, and that therefore today anybody who seeks damages, whether the case was filed before the amendment or after, that damages are limited to per person as opposed to per scan. But there are some state court judges that have disagreed with those Northern District of Illinois judges. So we're going to see a battle on that front. I will say, as a defense lawyer, I think that the Northern District got it right, and that the law merely clarified that it should be per person as opposed to per scan. But another prediction I'd make is just that I do think, as I mentioned earlier, it's not just going to be Illinois that has a private right of action. We should see in the next year or two, there's going to be other states around the countries that have a somewhat similar statute. So companies need to really be watching for that, because as it's demonstrated by a lot of what happened in Illinois, many companies, when they were sued under BIPA, asked, "What's BIPA?" And by then, the alleged violations had already occurred. So I do think that one of my predictions is there's going to be other states that follow suit in some way to Illinois in protecting in biometrics or genetic information.
Well, I hope those other states kind of learn some of the lessons that have come out of the BIPA statutes litigation to have the statute be well-defined and to have some reasonable guardrails so that we're not seeing companies pull out of the states that enact those statutes when it comes to cool and helpful and important technology that might be offered there. So I see Wayne has joined us again, so I think that probably means it's time to wrap up. And thank you everyone for joining us. And we appreciate the opportunity to talk about these important subjects.
Yes, thank you very much.
I wanted to thank both of you. I know this takes a lot of time to put that kind of quality presentation together, and you've got other things to do with your days, but you donated the time to our listeners and to Berkeley, and so I really appreciate that. I will leave you with one thing, great legal information, but I learned something very important I'm going to take downstairs to my son, who is looking at college in Illinois. And so it seems like he's going to need to know what a manual time card is. So I don't
Yeah.
think he's ever seen one. So there we go. Another piece of technology.
There you go.
So with that, thank you again so much. And we look forward to hearing from you again.